Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law and probate attorney in New York. Where am I looking? Am I looking in the right spot? I have a question today that was posed to me, and I'm just going to repeat it. Can you do a trust for a person if they are senile? I never actually heard the question asked like that until today. And so I wanted to think about whether senile was a word that has a legal definition, and so I looked it up. So I put it on my computer screen. I feel like it looked good all day, and now maybe I'll just tie it up. Senile. I looked it up. It's right here on the screen. It's an adjective having or showing the weaknesses or diseases of old age, especially a loss of mental faculties. So if that's the case, you cannot do a trust for such a person, right? Because they're facing the loss of mental faculties. Now, it's a little bit of a hard line in that regard. The issue comes down to one of capacity. Does the person know what they're doing? Do they have the presence of mind and the present sense awareness of who they are, what their estate consists of, and who their bounty, who are the natural, their heirs, the natural heirs. So that's how I would address the question. I have a situation now where a husband came to my office looking for my assistance because his wife went from a hospital. She went into a hospital as a result of a seizure, and at the tail end of the hospital stay, she went into a rehab, and he wants her home. Now, the rehab center is saying that she cannot be discharged because he used the word incompetent, because she is incompetent. So that's what a psychiatrist hired by the rehabilitation center advised him. So now we have this circumstance that he's going to need a guardianship. He had no prior. This is a gentleman in his 70s, wife is slightly older, and they have no estate planning documents, and he doesn't have any healthcare proxy or power of attorney or any documents for her. So we have to do a guardianship. So circling back around to the questions, if a person was exhibiting signs of senility, right, losing a loss of mental faculties, well, it would have to be fact specific, because that's not a legal definition. That's not a medical definition, as I understand it. So a person could have moments of lucidity, right? They might forget where their car keys are. Maybe they might forget, I don't know. I was starting to think of examples, but if they forget who their children are, that would be an issue. Couldn't do an estate planning document for that person if they forgot their spouse. Now, if they forgot the president, if they forgot certain things, I'd want to engage in a conversation. I also don't want to make myself a witness, and I don't want to go against any diagnosis. So if the person had a diagnosis of dementia or Alzheimer's, I'd have to engage that person. And you really could have that diagnosis and still have capacity to make your own documents. So I feel like I flim-flammed, wishy-washy around this. But these are very fact-specific, situationally determinate situations. If you want me to wrestle with your situation, please reach out to me, frankbrunolaw.com.